Ana Sofia Rodrigues is Chief Economist and Head of the Bureau of Economic Studies and Market Monitoring at the Portuguese Competition Authority, and currently she is President of the Association of Competition Economics, ACE. And before that, Ana was a senior competition expert at the OECD and worked in various positions at the Portuguese Competition Authority. And well, Ana does also have academic credentials. She holds a PhD from the University of York in economics, a PhD in economics. Thank you, Ana, for being with us. The floor is yours.
Thank you very much, Martin. Good afternoon to everybody. Thank you very much for this kind invitation to be part of this great seminar series with a track record of excellent speakers. So I'm honored to be here, even if virtually. And I'm also happy about the timing to talk about no poach agreements in competition, because this is in the order of the day. Just last week, Executive Vice President Vestager has warned against no poach agreements, stating clearly that they have a very direct effect on individuals and competition, and announcing that there might be down rates in order to investigate no poach agreements. So this is a great timing, because I think this is the most proeminent statement at the EU level regarding anti-competitive agreements in the labor market. So I think this is taking off now here in Europe. It's a more established topic in the US, in the other side of the Atlantic. And as I said, a great timing to be speaking about this. So let me give you a quick overview of what I will be talking about in this intervention. So I'll basically start with some simple definitions of no poach and wage fixing agreements, two types of anti-competitive agreements in labor markets. Then, once we have these definitions in mind, do a bit of setting the scene for the discussion with the relevant context. Then I'm going to speak about two advocacy initiatives by the Portuguese Competition Authority, which are very recent, just from last month. An issues paper on anti-competitive practices in the labor market, and a best practices guide to prevent this type of agreements. Then speak a bit about why worry with this type of agreements, the potential harms that they may bring, and this is what we address also in the issues paper. Then discuss a bit the framing of no poach, but also wage fixing in the framework of competition law. Speak a bit about the best practices that we put forward for the different stakeholders. And then finally, speak about two interventions. One is a case that is being investigated. So there was a statement of objections. It's the first no poach, a standalone no poach case that the Portuguese Competition Authority is investigating and analyzing. And the second intervention is an advocacy intervention, which is also quite recent. So this is the roadmap for my presentation. In terms of definition, no poach agreements are horizontal agreements whereby companies mutually agree not to make spontaneous offers, what is called no cold call, or to hire employees from other companies involved in the agreement without prior consent. Wage fixing agreements, on the other hand, is when firms agree to harmonize, to standardize salaries or other employee benefits. So these are the definitions, the two types of anti-competitive agreements in the labor market in which we focused. Now, why this debate and why now? Why is there an increased attention regarding anti-competitive, regarding in general competition in labor markets? This followed from a lot of empirical literature that has started emerging, mainly from the macro universe, regarding documenting an increase in concentration, an increase in markups, which is being accompanied by a decrease in the share of labor in GDP. So there's several excellent papers that have documented these. These trends are more persuasive in the US than in Europe, but they are international. And they have steered the debate on the potential reasons for this trend. There's several reasons that have been put forward, maybe some under enforcement of competition law. And one of the reasons for this decreasing share of labor in GDP that has been put forward has to do with the strengthening of the buyer power on the employer side vis-a-vis the employee side in the market, which has translated into this decrease of the labor share in GDP. Also because this means that employers have the ability to set wages below the marginal revenue of labor. Now, this is one of the reasons that has, or one of the relevant developments that has stirred this debate. Another one has to do with a joint statement by the US agencies, the DOJ and the FTC, in October 2016, stating that no poach and wage fixing agreements are per se restrictions to competition law, to the Sherman Act. This is, of course, not new. In the US, there have been prior civil suits by the DOJ and the FTC. However, in 2016, not only do the DOJ and the FTC clearly state that naked no poach agreements and wage fixing are per se restrictions of the Sherman Act, of Section 1 of Sherman Act, they also announced that after 2018, these agreements can be pursued or prosecuted as criminal offenses. And this has indeed been the case with the first criminal accusation by the agencies, I think the DOJ, if I'm not mistaken, in January this year. Now, another event that has put the spotlight into this type of agreements, and that follows also the debate around the digital economy, is the Silicon Valley case of no poach agreements. This is probably the landmark case, the most talked about no poach case and no poach antitrust case ever. And it involved the main tech companies in Silicon Valley that engaged in no poach agreements. These were mainly 5 bilateral no poach agreements involving Apple, Google, Adobe, Pixar, Intel, and Intuit. And in these agreements, the firms agreed not to solicit each other's workers without prior consent. They all included no cold calls of employees. So basically the firms agreed to refrain from contacting and trying to recruit proactively each other's employees. This covered all employees of both parties to the agreements. And how was this implemented? Basically, managers informed the recruiters which potential hires were off limits. There were lists for some of these firms in the HR department, the recruitment department. There were lists of the employers, of the potential employees that were off limits to be the object of cold calls. And whenever there was a deviation, there was a contact by the counterparty in the agreement to the senior managers reporting that there was a deviation from the agreement and asking the manager to put this to a stop. So this was a purely no poach case. So there was no wage fixing. There was no harmonization of the wages paid to employees. And in 2011, there was a court decision as a consent judgment. What decision is this? Basically, the parties do not confess to the practices. However, they accept remedies to resolve the practice. So I think that this is probably the context that spurred the discussion on no poach and wage fixing agreements at the EU level.
May I interrupt you quickly?
Sure.
Could you remind us or tell us, so under which law was the Silicon Valley case dealt with?
It was Sherman Act.
Okay,
if I well recall.
Okay, perfect. No, that's.
Okay. I think it was. I think it was the Sherman Act. It was dealt by the agencies directly. So there's a lot of no poach cases in the U.S. that are led by prosecutors. I don't think that this is the case for this one, but I can check. I don't recall. But I think it was the Sherman Act.
Yes, if I could just intervene, it was under Section 1 of the Sherman Act, and in particular, it was private litigation as well that was involved in that.
Hello, Joe.
Yeah, hello.
Nice to you. Okay, so at the EU, as I was saying, developments are much more timid. When we started discussing within the Portuguese Competition Authority about 2 years ago how to address these cases, there was very little even research that we could find on no poach agreements. There was no statements at the EU level on this regard, and this is why I'm quite happy to see that I think probably these 2 weeks mark a very important change, because this is being discussed from what I recall for the first time at the European Commission level. So in terms of decisions, there's some decisions finding no poach agreements, but within the context of a wider cartel. So not as a standalone agreement. These decisions do not specifically state that no poach agreements per se would be a violation of the competition law, but as part of a wider cartel that involves coordination on other elements of competition, including price fixing. Some examples you have in France, the Autorité de la Concurrence has a decision regarding coverings, floor coverings, in the industry of floor coverings. You have a decision by the Spanish Competition Authority in the transport sector, in the hairdressing sector. But as I said, these decisions, they all relate to wider cartels in which there was price fixing in the downstream markets. There's a decision by the Dutch Court of Appeal, so not by the Dutch Competition Authority, but the Dutch Court of Appeal, that has ruled against the no poach agreement, declaring it as void and as violating national competition law. And this was an agreement between Dutch hospitals not to poach each other's anesthetists. I hope I pronounced that right. I tried to train that. It's not very easy to say. Okay, in terms of the work from the Portuguese Competition Authority, we published an issues paper in which we basically addressed the implications, the effects of no poach and wage fixing agreements in the labor market. We reviewed the existing literature, the existing case law, because we thought it was important to make it clear what our stance was and to raise awareness as to the potential negative impacts of these agreements. The first discussion that when we started addressing this was, but is this about harm to workers, or is this about harms to competition and consumers, or both? And this is one of the issues that we address in the issues paper, how it affects the labor market, how it affects workers, but not only workers, the labor market, what kind of distortions it introduces in labor markets, and what kind of impacts this has also in downstream markets. We also take a clear stance as how the Portuguese Competition Authority will take these agreements in light of the Portuguese Competition Act. So we take a quite clear stance on this. And then what we did was, at the same time, we thought that because we had no leniency or no complaints regarding no poach and wage fixing agreements in Portugal, we thought it was important to go a step further in raising awareness that this can be a violation of the Portuguese Competition Act. And we published as well a best practices guide on how to prevent anti-competitive agreements in labor markets, a very small, a very short, very clear-cut document with the do's and don'ts for firms, with the definitions. By the time we had a few meetings with recruitment agencies, they were aware of these type of agreements, and they had different terminologies like gentleman's pact, gentleman's agreements, non-aggression pact, and so on and so forth. So we included all the expressions regarding this type of agreements, so that firms, recruitment agencies, and other employees were aware of these type of agreements, that they're secret, that they may affect them, that may affect competition. We announced the possibility of leniency for these type of agreements, the fines that could emerge for these type of agreements, and this is what we address in the best practices document. So both of these are available in English in our website. I included the links there. We first did a public consultation in this document in April 2021. We received contributions from workers' representatives, consumer association, business associations, and companies. We took their comments into account. We did a report, which is the report on the public consultation is available in English only. But it was quite important, this public consultation, because we understood where we needed to be more precise as to more specifically on the information and the setting where the exchange of information can take place. And I'll get back to that in a little while. So after this public consultation, we published the final versions of these documents on the 21st of September last month. Now, what we address there, and in terms of effects of no poach and wage fixing agreements in labor markets, we tried to think about all the potential effects that we can find in the literature, that we can imagine taking place. So in terms of the labor market, we highlight how they may strengthen firms' buyer power vis-a-vis the workers, basically by increasing the switching costs for workers and reducing the potential alternatives that they may turn to when looking for a job or when seeking to change jobs. Obviously, the strengthening of firms' buyer power vis-a-vis their employees is particularly important if a significant share, or even if all the potential employers of a given type of worker are involved in the agreement, and then you have basically an oligopsony or even a monopsony structure in the demand side of the market. By strengthening these buyer power, firms can set wages, they can deviate wages from the marginal revenue of labor. Just like it happens in any other input market, monopsonists may strategically withhold demand for labor in order to induce a reduction of wages. This is more of a concern when upstream markets are fragmented, when they're atomized, and in particular when workers are not organized through collective bargaining, which is also something which is very currently into debate, given the initiatives of the European Commission on this regard. Now, we mentioned that there's empirical evidence on the effects of no poach agreements in the labor markets. Regarding the Silicon Valley case that I have just mentioned earlier, there's an empirical analysis using diff and diff that shows that in the time window where these no poach agreements were in place, there was a reduction of 2 to 4% in the level of wages. We also noticed that in the labor market, these no poach agreements can reduce worker mobility. They can reduce investment in human capital, and I will address that more in detail in a little while. And they may decrease the job match quality, therefore leading to an allocative inefficiency. And that brings me precisely to the impact.
Sorry, can I interrupt?
Sure.
So just looking at the list of points you had on the previous slides, I was just wondering, I mean, so I guess all these points could be made about a buyer cartel, you know, in input markets. So is there anything that makes labor markets special, or that requires a special discussion, or?
Well, I don't think so. But okay. But initially, that is my reading. I don't think that this is too special. I think this is a buyer cartel. Basically, when you have fixing the price of an input, it is a buying cartel. Buying cartels and their competition. There's.
Sorry, can I just interrupt? It seems to me that there is a difference, right? I mean, I guess you can easily find efficiency defenses for no poaching agreements, right? I mean, having to do with, you know, investments in workers and about potentially about secret information and so on that workers might have, you know. So it's not that they're, which is harder to do.
Couldn't you make the exact same point for input suppliers?
Cartels, yes. I think you can also have some efficiency defenses. Regarding Volker, what you were mentioning, our take on this regarding investment in training, for example, which is often alleged by firms as a reason for no poach agreements, that they invest in training, and in order to ensure that there's a low risk that they will lose that investment, they need to resort to restrictions to worker mobility so that they can recoup the investment in training. It's also true that there's other ways to protect investment in training and to try to retain workers. You can have retention policies. You can have training that is contingent on workers staying in the firm. You can have repayment training cost agreements with the workers, and you can have better wages in order to retain workers as well.
But I mean,
right?
Sure, but there is clearly a hold-up problem potentially, right? I mean, sure, you try to keep them, but there is a hold-up problem.
Yes, there's a hold-up problem. As I said, our take is that the no poach agreement is not a proportional mechanism to address this. That is basically our point. Then another efficiency that is often referred to, which is even, I think, more controversial, is that by reducing wages, firms save on costs, and that you have an efficiency there. Obviously, that sometimes this reduction in wages is accompanied by a reduction in output that has a negative impact on welfare. But also, often the wages for the regular hours paid are more of a fixed and a variable cost, and thus less likely that they're passed on to consumers, and they won't meet the criteria of Article 103 to be considered as a countervailing effect to be considered, given the negative impact of the agreements on competition. So as I said, there's also reasons for efficiency reasons that can be put forward for buyer cartels, but in general, what we think is that there are other less restrictive ways of achieving those same outcomes without restricting competition. So that's our stance, at least. And we take it very clearly in the issues paper. So anyway, but it's also important here to mention, and as I said, this brings me still mentioning investment and training, which is important for quality. But there's another dimension that is very important for quality too, which is innovation. And here, what we mention is that this lower mobility of workers may lead to or may limit knowledge spillovers. So If you have this kind of agreements, firms are left with the option of in-house training if they want to acquire a given expertise or a given know-how. And this there's some evidence between a positive correlation and productivity in high R&D intensive industries. And thus, because of this, the no poach agreements may also lead to a reduction of innovation. Of course, there's limited empirical analysis on this because these agreements are secret. But doing here an analogy or looking at the impact of non-compete, whereby an employee agrees not to compete in the future with the employer, there's a little bit more of empirical evidence from what I recall. And at least in low risk industries where there's more incremental than disruptive innovation, these non-compete clauses have been shown to be able to inhibit entrepreneurship, reduce the innovation rate, reduce the rate of startups. As I said, and in these cases, they may as well hurt consumers by hurting innovation. Obviously, we know that this is not necessarily the case when there's high-risk projects where results are more mixed, but still that's another negative impact of no poach agreements that they can have also on innovation and thus then quality and variety. We highlight the clear inefficiency that these agreements might generate because they basically distort the allocation of the labor input, so workers will not be allocated to their best use, which would be the outcome of an undistorted, a competitive labor market, and this will then translate into higher inefficiency, which will have an impact in downstream markets and thus consumers.
So may I ask you,
sure.
So these, are you treating no poach and wage fixing as substitutes, or is it particularly bad if the two are together? Because currently you just list all these possible harms, and so I don't know, is it, do you treat them as symmetric, and is it, if one of them is already bad, well then the second one isn't added, wouldn't be worse? So how is the view there?
Well, the two together are certainly worse than each other alone. No poach can also actually be, even if you have only no poach and you don't have wage fixing, no poach can be an indirect way to affect wages, because wages will likely go down if you have no poach agreement. So it's kind of also of an indirect wage fixing, or at least a suppression of the market discipline on wages. Some of these effects are stronger if you have no poach than wage fixing. I'm thinking, for example, in terms of mobility, no poach worker mobility, no poach should have a more stronger impact on labor mobility than wage fixing. Obviously, wage fixing will also reduce labor mobility because it will change how the relative wages between firms, and they thus reducing worker mobility. But no poach, for example, will have a more direct impact on that. And sometimes the two can go together, of course.
If I could just insert here, also, I think one important distinction is, no poach is basically saying we're not going to compete for each other's current employees. It's kind of like a customer allocation scheme, but that doesn't mean we don't compete for new employees, new employees in the market. A wage fixing agreement would actually affect that as well.
Exactly. Because the no poach is only usually just to the employee, the ones that are hired. Exactly. Thanks, Joe. That's a very good point. Okay, now no poach and wage fixing can also have an instrumental role in market sharing agreements between competitors. We were brainstorming on this, and there's an obvious case in which if the customer portfolios that are associated with each worker are important, in these cases, the no poach agreements may be seen as instrumental. So if you agree not to poach each other's workers, and customer portfolios are very important, you're basically agreeing not to poach each other's clients. And then if there's a geographical dimension to customer portfolios, it may be also a mean to achieve market sharing, geographic market sharing. We also know that in order to implement and monitor no poach agreements, firms will have more frequent contacts. They may exchange information, sensitive information about their recruitment policies. This will soften competition in labor markets, and it will strengthen the conditions for collusive behavior downstream. So in general, we think that this signals poor competition. Another situation that we were brainstorming internally was no poach agreements being used as a way to soften competition by strengthening specialization. We were thinking of, for example, hospitals that are specialized in certain areas and agree not to poach each other's doctors. Then in this case, you can have basically increasing the specialization of these hospitals and reducing competition between them. Another situation would be, because we're in the competition community, we have lawyers. If you have, for example, law firms, one specializes in competition, another one specializes in labor law or wherever, and they agree not to poach each other's employees or partners or whatever, and then you can have basically the effect of market sharing through specialization. Now, in terms of the impact of these agreements on quantity and prices, we discuss in the issues paper that these effects of no poach agreements depend on the extent of the no poach agreement, the coverage of the no poach agreements in terms of qualitative and quantitative representativeness, so the share of the workers that are assigned to the companies involved, but also the market power of the companies downstream. Obviously, the effects are likely to be more negative the more the market power of the firms that are involved in the agreements. If firms have a small market share and they have the firms that are involved have small joint market share and little market power downstream, then what you expect is that they do not have an ability to have an impact on the price of the labor market, and thus you would expect other companies, and also in the the relevant markets downstream, and you would expect the competitors to expand production as a reaction, and you shouldn't expect an impact, a reduction on quality because of the no poach agreement between these firms that have little market power. On the contrary, however, if you have a large market share or a large market power for the firms that are involved in the agreement, you would expect this no poach agreement to lead to a lower quantity of labor being employed. This would mean also lower input and potentially higher prices. As I said, the cost savings are not likely, any potential cost savings are not likely, at least more often than not to be passed through to consumers. And in the long term, you can have also a loss of productivity through various ways, including the reduction in investment in human capital, and you can this can lead dynamically to a further reduction of quantity and an increase in prices, thereby harming consumers. Okay. Now, what we discuss as well in the issues paper is how to frame these agreements in terms of competition law. As I said, things are very clear, the stance of the DOJ and the FTC, both in terms of practice with a number of cases, but also in terms of the guidelines, in which both agreements are taken as per se infringements of competition law. In this side of the US, of the Atlantic, then you can think about what kind of clear statements are out there regarding horizontal agreements on the demand side. One usual reference that is made is to make an analogy with joint purchasing agreements that are restrictive by object only when they serve as a tool to engage in a disguised cartel. Personally, I don't think that this is a good analogy. I prefer to, I think it is much more accurate to make an analogy with, it's not an analogy, it's as taking them as sharing sources of supply or fixing input prices. And there you have jurisprudence that treats these agreements or confirms these agreements as by object restrictions. And I'm thinking, or I'm referring here to the raw tobacco cases. So as I said, there's little or no practice of standalone no poach agreements, so in which no poach are fined just on their own without being part of a wider hardcore cartel. There's a case in Finland which there's very little information, which I cannot exclude. It looks like it can be a standalone no poach, but more generally, the cases that exist, the Spanish, the French cases, they are all part of an horizontal, an overarching supply side cartel agreement where firms also agree on other dimensions that we know are traditionally straightforward hardcore cartels and treated as per se as by object restrictions. Now, what we clarify, the stance that we take is, as I said, to make an analogy or treat them as any other buyer cartel. So we, in the issues paper, we warn that no poach and wage fixing agreements may be subject to fines as agreement between companies, concerted practices, or decision by association of companies within the meaning of Article 9 of the Portuguese Competition Act, and if applicable, Article 101 of TFU. So both through the Portuguese Competition Act and the TFU, companies and association of companies, if engaging in this type of agreements, are liable to be punished with fines that go up to 10% of their turnover. In Portugal, individuals can also be fined on up to 10% of their annual remuneration. In this newspaper also, we mention, of course, that for any other restrictions, there can be leniency applications, and firms can apply to be granted a waiver or reduction of fines if they confess to engage in this type of agreement. So this is how we frame it in terms of competition law. Another thing is that competition law requires that these agreements are carried out by companies within the meaning of undertaking. So here it's important to make a distinction between the concepts of workers and undertaking. Look, these type of agreements may occur in a variety of markets. We've seen them in health, in railway, in technology, in higher education, hairdressing, transport, sports, but we can easily imagine them, for example, in banking markets as well, and other sectors. These are subject to trigger civil liability through private enforcement. And as I said, the cases in which they have been addressed, but however not as a standalone, is, for example, the cartel in the PVC and linoleum floor coverings from the French Competition Authority decision in 2017, where they were treated as a by-object case. And then also in Spain, the cartel between 8 freight forwarding companies, they were treated as well in that case as a by-object restriction. And here, clearly the Spanish competition authority speaks about the impact of these no poach agreements on workers, that they resulted in damages to workers, but also to competition. It explicitly states that because the hiring of workers is an important parameter of competition between companies. In both of these, basically, the companies agreed not to hire or recruit each other's companies without a prior consent. Now, in terms of the do's and don'ts that we put in our best practices guidance, so we basically advocated for firms eliminating hiring or wage setting policies that involve the agreements with other companies, not to refuse to solicit or to hire employees from another company, not to exchange commercially strategic and sensitive information about employee hiring and compensation outside legitimate contexts of social dialogues and or collective bargaining agreements, which is, as I said, something very topical, or as social partners. So the no poach applies wherever, even if you're within a social dialogue, you cannot engage in a no poach. What you clearly state that companies should not do outside social dialogue is to agree with another company to fix salaries or any other form of compensation, and to participate in meetings where sensitive information on salaries or any other forms of compensation is discussed. Of course, there's some degree of joint discussion on price levels within on wage levels within social dialogues and collective bargaining, and we clearly state that this is outside, that this is outside the scope of our intervention. This was one of the fine tunes that we made in between the public consultation and the final version, because we had some of the firms and business associations saying, well, but what if we're in a social dialogue? Can we exchange some information regarding salaries and other aspects of recruitment policies? And there we made it clear that yes, but not commercially strategic and sensitive information. So that was one of the things that we fine-tuned after the public consultation.
Could I ask a comment here, or ask a question and a comment? Yeah, I think this issue about information exchange is an interesting one. The EU, treats on terms of exchange of prices between firms in a more, I think, stringent manner than in the US. And I think the US actually should be more of the style of the EU. So my question is, basically, should it take a similar position to the exchange between firms of salary and wage information, as is done with the exchange of price information?
Well, in the issues paper, the sense we take is that, yes, the same principles should apply to the exchange of information on salaries or other aspects of employee compensation and the exchange of information. So what the most important aspect there is what you call commercially strategic and sensitive information. And also, the information that is exchanged, whether it's aggregate or disaggregate, whether it's information on past level of prices or wages or future level of prices or wages. So we think that the same principles that apply to the exchange of information regarding output prices should apply here regarding information on wages and other remuneration policies. So basically, I think the trigger here is determining what is commercially strategic and sensitive information that you cannot exchange, and that depends as well on the characteristics of the information that you're exchanging. So
I guess one thing they could say is that there is a tradition in labor markets of exchanging information, maybe through a third party, from the perspective of benchmarking to get a sense of what is a kind of competitive wage. There isn't that kind of tradition when it comes to prices. And so given that kind of distinction under, let's say, under a competitive model between how the sharing of prices, and there's not really a notion of doing that from the perspective of benchmarking, but there is a sharing of wage information from the perspective of benchmarking, does raise the question of whether it should be treated differently. It isn't clear to me, so.
Well, from what I recall, I think we treated benchmarking. So you have benchmarking aggregate information on wages that is being exchanged, for example, in collective bargaining. We think that this is less likely to raise competition issues, because as the benchmarking actually, Joe, and this is interesting that you're raising this issue, because this was one of the issues that were raised by the business association and the companies. Mm-hmm. Basically, they said, well, can we exchange information with a third party that aggregates the information for benchmarking purposes? We do not, obviously, we cannot ever say yes or no in a black and white form, but we said that, you know, aggregate information or information that is put together for benchmarking purposes that is not exchanged directly in between firms is less likely to raise competition concerns. So we agreed that in general, in the context of benchmarking and the way that it traditionally happens, it should be less of a concern. There's also actually exchange of information that is explicitly foreseen in the labor law. For example, you know, if a worker goes from a place to another, there might be a need to exchange information. And they also asked us, you know, if we need to meet exchange information to meet requirements of labor law. And they were mentioning situations in which clearly there was no anti-competitive purpose. Then that as well, we said that this is less likely to raise issues and concerns from a competition law perspective.
Okay, thank you, Anna.
Thank you. Okay, now the cases that we have, and there I'm a bit frustrated because I started writing the slides and then I said, okay, I cannot present all of this because this is not public information. So what I'm going to refer to is two initiatives. So we have an investigation regarding a no poach agreement in the football, I don't know how to call it, football sector, wherever in football. And we had also a recommendation in the football, female football league. Let me tell you a little bit more about this. So there was a no poach agreement between the Portuguese professional football league and the male professional football clubs in the first and the second leagues. Basically, there was a press release that was put forward by the league, the professional football league in Portugal, announcing that they had reached an agreement whereby football clubs agreed not to hire each other's football players who unilaterally terminate their employment contract, evoking issues related to COVID or any related decisions. So basically, this took place when we had when you know COVID was when the first wave started and we had confinement and everything. And basically what the football clubs were trying to do is to eliminate the options for football players. And they published this press release that we saw and that triggered our intervention. So they revealed this agreement in the website and they mentioned 2 meetings between the league and each of the clubs. This is a typo that took place in May the 7th and May the 8th, 2020. So when we saw this press release, what we did was we initiated ex officio proceedings against the Portuguese Professional Football League. We issued interim measures against the Portuguese Professional Football League, ordering them to immediately suspend the no poach agreement, subject to a penalty for each delay. Later on, we included the 34 member clubs of the Portuguese Football League in the season 2019 and 2020 as parties in the proceedings. And we issued a statement of objections against 31 of these clubs and the league as a facilitator in April this year. As I said, that there's not a lot I can say about the ESO. The only public element of information we have on this is the press release, but I can say a few things. In terms of, so we looked at harm to football players and harm to consumers. Obviously, the harm to football players is not necessarily the standard we need to meet. We need to meet the standard of harm to competition and consumers. But the agreement basically reduces the set of outside options for football players, so they have a negative impact on their bargaining power. I must say, although this is personally, my view, I don't know if this is in the ESO or not, actually, if this is mentioned there, but this agreement followed from an attempt of the league to negotiate a reduction in salaries with the football players unions, which failed. And then this agreement follows the failure to reach. So it's likely a second attempt to reduce wages following a first attempted failed attempt to reduce wages in conversations with the union. Another note on wage fixing in the female football league, more or less at the same time, there was a public consultation on a draft regulation that was launched by the Portuguese Football Federation that put forward a proposal to impose a ceiling to the wages of female football players registered for the 2020-21 season. As I said, this is draft regulation, so it was not implemented yet, but basically this package allegedly sought to deal with the financial impact of the COVID pandemic on football clubs. The ceiling was imposed on the joint value of the wages paid to the female football players. And again, this was brought to the attention by the competition authority because there was a press release by the Portuguese Football Federation announcing that they had reached this agreement with the union. No, sorry, the ADC issued a recommendation to the Portuguese Football League Federation, warning that the ceiling on wages should not be adopted as it could lead to competition concerns and amount to an infringement by wage fixing. And the Portuguese Football Federation dropped this from the draft regulation, so it was not implemented. So this was an advocacy initiative, a recommendation rather than an antitrust intervention.
But I have a question. If it's a centralized union, which has been sitting on the other side, it is in a way centralized bargaining. And then I don't understand why you would intervene with competition law.
Well, we didn't say it was an infringement. We just said it could amount to an infringement. Because
but could it if it's centralized bargaining?
It depends on how the bargaining power is distributed. So this is the two interventions that we had at the Portuguese Competition Authority. As I said, the other one is an antitrust, is an ESO, and there's still no final decision. And I would stop here. I don't know if you have any further questions.
Thank you very much, Anna.
Sorry.
Thank you very much, Anna.
Thank you.
Let's clap our hands. Do it the way you like to do it.